Thank you for joining the fourth and final installment of Digital Crossfire 2014, the electronic version of the annual Realtors in the Crossfire program from your NHAR Legal Committee and Risk Management Subcommittee. Digital Crossfire is an interactive workshop designed to improve your risk management awareness for hot-button real estate issues, including this installment on the subject of off-site disclosures. Hundreds of New Hampshire realtors took our recent true-false quiz on the subject, and here are the results along with a brief discussion regarding the issue. Introducing Matt Johnson and Bill Weidacher.
Hello and welcome to our fourth installment of Digital Crossfire. It's our final installment. Today we're going to be talking about off-site disclosures. My name is Bill Weidacher. I'm past president of the New Hampshire Association of Realtors, and we have Matt Johnson, who is counsel for the New Hampshire Association of Realtors. Good afternoon, Matt.
Good afternoon.
Our first question today is true or false? The existence of a registered sex offender living next door to the listed property is an off-site condition.
60% said true, 40% said false. The correct answer would be true. If you have actual knowledge of the existence of a registered sex offender living next door and nearby, that is an off-site condition and something that needs to be considered carefully in the listing.
I think we got to refer also back to the association's position on Megan's Law and take a real hard look at that and make sure that we have a good, clear company policy on how we act.
Absolutely, and refer to the seller disclosure statement, which does address this issue and puts any prospective buyer on notice that if they have issues about this topic, that they should consult the appropriate resources, which would not be the listing agent.
Great. Question 2, true or false? The New Hampshire license law requires you to disclose off-site conditions that may affect the property.
So that was a little bit of a tricky question. The true answers were 61%, false was 39%. The actual correct answer was false. License law only requires agents to disclose information about on-site conditions, and even then, the on-site condition has to be something where the agent has actual knowledge.
Great. So as I look at that, the majority of us answered that question incorrectly, and that is because we have this tendency to want to disclose anything we know.
Well, and it's a tricky area and it's a gray area because license law sets tight parameters, but that's just license law. Civil liability, if you were brought into court by a buyer or seller who is seeking money damages or to undo the transaction, it's going to be a broader standard, and information you had actual knowledge about relative to off-site conditions can impose liability. So it is something you need to be careful about in dealing with this situation.
Great. Let's move to question 3, Matt. True or false, an agent should not discuss potential off-site conditions with a buyer or seller?
That one, there was more unanimity of opinion. True, there was 12%. False was 88%. The correct answer was false. Agents should discuss off-site conditions. They are important. They do impact a buyer's decision to buy a property. So if you have actual knowledge about them, they should be discussed.
Matt, our fourth question, true or false, a listing agent and his or her broker could face potential civil liability for failing to disclose off-site conditions such as major construction or highway projects, nearby contaminated properties, or airport flight patterns. If he or she has actual knowledge of such off-site conditions, how did we fare on that question?
The great news there is people got that question mostly correct. The true answer was 89%. The false answer was 11%. The correct answer was true, so the realtor community does have a good sense that they need to disclose off-site conditions of which they have actual knowledge. Again, the trick is actual knowledge. The question always comes up, what happens if I just have a little bit of knowledge or maybe I'm not 100% certain about something? The advice that I would give is at that point in time, alert the seller to the fact, encourage the seller to do some research or investigation, and if the issue bears out to appear to be accurate or appear to be likely to happen, encourage the seller to amend their seller disclosure statement to reveal that off-site condition. That provides the maximum liability protection for real estate agents and also for their seller clients.
So this is one of those occasions where you could be in compliance with license law, but yet still be civilly liable for knowledge that you have and did not disclose.
Absolutely, that is the challenge. The Real Estate Commission would say no finding of a violation because it's an off-site condition, but a court or a jury could find you negligent for failing to disclose information about the surrounding properties that you had actual knowledge of.
Let's move on to question 5. True or false? If requested by a client, it is the responsibility of the agent to research and advise upon potential off-site conditions for that client. True or false?
So here there was a split in the community. True 46%, false 54%. The correct answer was false. The question is a little bit tricky because it speaks about research and advise on potential off-site conditions. That is something an agent can do, but is not something an agent must do, and it's not necessarily something we would recommend from risk management purposes that you do. That does not have to be your obligation. We would advise and encourage you to steer the seller towards sources of information or buyers towards sources of information so they can make their own independent investigation.
Sure. Final question, true or false? The source of any disclosure about off-site conditions that might affect the property should be the property owner.
And here, 31% of you said true and 69% false. The correct answer was true, that the source should be the seller. Again, as I mentioned earlier in the video, the best source for disclosure of any off-site or on-site conditions is the seller, and the best vehicle is the seller disclosure form. It is in writing, so there is no ambiguity about who said what to whom and where, and it protects the real estate agents involved in the transaction, and it protects the seller involved in the transaction as well.
Again, thank you for tuning in on Digital Crossfire, and if you have other ideas or topics that you think we should be addressing, please send them in to the New Hampshire Association of Realtors, and we look forward to future editions of Digital Crossfire.
Thank you.